90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. As part of our continuing series about the COVID-19 and how it affects lawyers and business people and others who are challenged by this, we have a special guest, Matthew Weinick, and he's a partner in a law firm that deals with employment law and other COVID-related issues. Matthew, just tell us the firm that you're with.
Sure. Good afternoon, Ken. Thanks for having me on. The firm is Famighetti and Weinick. We're in Melville, and we concentrate in the area of employee rights.
Okay, employee rights on behalf of employees.
On behalf of employees, right.
And what kind of rights do you advocate? I know we'll cover COVID-19 in a moment, but what type of rights? Yeah,
so the big picture is discrimination, retaliation, unpaid wages, and overtime. More specifically, some of the cases that we see are cases like sexual harassment, hostile work environment, wrongful terminations, and workers who aren't paid either minimum wage and or overtime, which they're entitled to under the laws.
Okay, and now fast forward us to some of the issues for employees arising out of the COVID-19 and how it's changed the workplace so drastically. What are some of the newer issues and skills and recourse that employees may have?
Yeah, so there's no shortage of issues right now. They're plentiful and they're wide-ranging. So, of course, there's a lot of layoffs right now. So that, of course, implicates unemployment insurance. So unemployment insurance through the Department of Labor and the new laws that are coming out of the federal and state governments concerning unemployment are hot topics. Worker safety is huge. From the employer perspective, keeping their workers safe and providing a safe workspace, and from the employee perspective, workers who are concerned because they have underlying medical conditions and they're worried about contracting COVID and becoming sicker because they're at risk. These are some of the bigger issues we have. There's leave issues relating to people who need to take care of either family who's sick or children who aren't in school or in their daycare, and they need to be able to provide care for them during the day.
If you don't mind, perhaps we could take a moment discussing in brief each of those issues and how you can advocate for your employee clients. Let's talk first about underlying health conditions. Who might be able to have some recourse about, let's say they're working at home or they're not working and their employer wants them to come back to a physical workspace?
Yeah, so the law that implicates most directly in a situation like that are the disability discrimination laws. So there's a federal law and there's a state law. On the federal side, it's the Americans with Disabilities Act. On the state side, it's the New York State Human Rights Law. And actually in the city, there's also the New York City Human Rights Law. And these all have disability discrimination provisions in them. And what they provide for is that an employer must provide a reasonable accommodation to an employee who has a medical condition and requires a reasonable accommodation to be able to perform the essential functions of the employee's job. So what we're seeing is first a question of whether you have a medical condition that qualifies you. That's always the first question. So if you have, say, asthma, if you have an autoimmune deficiency problem, which might qualify as a medical condition, these are just some of the things that we're seeing people call us about. People with those types of conditions that are worried about going into the workplace. And so the second question is the reasonable accommodation. So the employee has an obligation to ask the employer to provide a reasonable accommodation which allows them to perform the essential functions of their job, as I said. So And what's reasonable is a question that's particular to each circumstance. So we always advise people with questions to speak directly to a lawyer who's knowledgeable in the subject matter to help determine what might be reasonable. But some things that are recommended by the EEOC, which is an agency that governs these types of rules and regulations, is barriers. So a face mask might be a reasonable accommodation. Certainly hand sanitizer, having a person work in an area of the office where there's less traffic. Those might be things that are reasonable accommodations. We're learning now that people can work from home much more easily than people thought. So I think for many people, working at home can be a reasonable accommodation. And it's up to an employer and employee to engage in what's called an interactive process to kind of brainstorm and figure out what might be a reasonable accommodation in any particular situation.
If a person needs, let's say, a germ-free environment or fresh air, or their immune system is compromised or weakened, does that help them make their case?
So that's it's a great question. A germ-free environment, I would suggest, is probably not reasonable. So I've actually blogged about this example. In particular, if an employee needs a kind of a hermetically sealed chamber to be completely free from the possibility of being exposed to COVID, that's probably not reasonable. And that's not what the law requires, that it be completely germ-free, that the risk be completely eliminated. But the employer does have to take some reasonable steps. So like I said, disinfecting the workstations, moving workstations further apart, things that the CDC recommends as far as controlling exposure.
Anything in terms of cleaner air, because a lot of our buildings, you cannot open windows to get fresh air, and germs may be spread because of that?
It may or may not. Again, we would first probably look at CDC guidelines. So if the CDC said that maybe putting in an air purifier might help, that could certainly be a reasonable accommodation. Completely overhauling an HVAC system probably isn't a reasonable accommodation because of the cost. That might be an undue burden to an employer. But any steps that can be taken to mitigate the risk that are a minimal burden and that might reasonably lead to a decrease of the risk of exposure, I think, could argue.
For all these reasons, should the employer reconsider their notion of having the employees return to the workplace or be in the workplace at the same time?
It's certainly a question that employers should ask themselves. Again, it's such a broad question. There's so many different types of workplaces, but I think one thing we have learned and one thing we're talking about in the employment lawyer community is, we've proven that we can, or many of us can, work at home. And a call I'm getting quite frequently from employees is, I've been working at home for 2 months. My employer is opening up. I have such and such medical condition. My doctor says I shouldn't leave the house. My employer is still making me come back to work. I think it's a very hard position for the employer to say, well, you worked at home for 2 months with no problem. Now you need to come back or you're going to lose your job. I don't think that that's a reasonable position for an employer to take with a proven track record of allowing workers to work at home.
And what about the commuting factor? Let's say some workers, it's not so much the workplace, but their ability to physically go to the workplace through the railroad, through a subway, through a bus may also come. Even if the workplace is safe, their transportation may not be as safe.
Yeah, that's true. That's unfortunately something outside the scope of the employer's responsibility. So, the employer doesn't have control over the LIRR, for example. But certainly, if an employee can reasonably work at home, that sounds like it's probably a reasonable accommodation in most circumstances. I think an employer would have a hard time showing why making an accommodation for somebody who couldn't use the LIRR or who can use an Uber or something like that, why they shouldn't still be allowed to work from home.
So it's best that there be an open discussion about the concerns of the employer and the concerns of the employee to see if they can reach some compromise, even if it's only to have a smaller workforce spread out in the workplace and alternate when they come in.
Yeah, you're 100% right. On the first part, you suggested something that's written into the law, which is called the interactive process. So employers and employees must talk about these issues. An employer can't just outright reject when an employee comes and says, I need a reasonable accommodation, they have to work with the employee. And so, the shift schedules might be something that, employers look at. Frankly, that's something that I think I'm going to do in my law firm. We're very, very small, but still there is a workspace where there are several individuals that would work closely together, and I'm probably just going to have a shift in the week. So one person works 2 days in the office and the other works, vice versa.
But I want to remind our listeners that you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College. We're talking about safe workplaces. Our guest is Matthew Weinick, and he's talking about some of the employee rights when it comes to protecting themselves in the workplace, especially as someone returns to work, and how employers have an incentive to try to keep it safe for everyone. And this podcast and many other programs from Law You Should Know, as well as other programs on WHPC, are available as podcasts at nccradio.org. What about in terms of customers and clients coming to the office? How do you think that will change as we go forward?
Yeah, so there's also a duty to, under, again, the ADA, a different section, but there is a duty to provide reasonable accommodations to in places of public accommodation. So there is certainly an obligation to comply with those laws and to be able to provide a safe environment for customers and clients to enter. So I think that's already being implemented. You see it in the grocery stores that there's plexiglass dividers or sneeze guards, I guess they're calling them now, to protect the cashier and the customer who's on the line. I was actually at a car dealer today, and it was appointment only. And then we were brought in and brought directly to a desk where there was the salesman who was also behind plexiglass, and we were on the other side of it, talking about the deal. So I think those types of things you'll see, capacity issues you're going to look at, and barriers you're also going to see. And, of course, face masks, I think, are going to be required in most public buildings.
And so even in the workplace itself, in a shared space, there are going to be barriers, greater distancing, maybe some rules on, even around the office, how close people can be. Exactly.
So those are the things that the CDC is recommending, and the EEOC, again, which is the kind of the workplace watchdog, to just make it easy to talk about what they do. The EEOC is also kind of deferring to the CDC on what employers should do to keep their work space safe.
And it's good to have a dialogue with your employees. You want them not to worry. You don't want them to be distracted. So you should try to reach some accommodation that works for everyone, especially if they're a valued employee.
Yeah, I mean, that's certainly a very practical consideration. I don't think you want a workforce that's scared to come to work. So I think it's important to communicate the steps that employers taking to make the workplace safe. That it's little things like that make a huge difference. When an employee doesn't feel safe, but perhaps the employer is doing things that the employee doesn't see to make the workspace safe, well, that's when they come and talk to a lawyer and they say, well, they're not doing anything because they might not see. Maybe there is a new air purification system or something that's kind of behind the scenes that people aren't seeing. And then they run to a lawyer and say, well, I'm not being kept safe. And then there's legal issues. So if you communicate, I think that kind of, puts minds at ease, at least.
And the relatively new notion of shared space where a dozen people would work next to each other around a conference table, the open style of meeting, maybe suggested by Mayor Bloomberg, that's really gone now.
Yeah, I think, again, we've shown, if nothing else, that there are other ways of meeting rather than face-to-face. In the general workplace, the Zoom meeting, obviously we're doing this by Zoom. I don't know if that's a secret to your listeners or not, but we are doing this by Zoom. People are meeting by Zoom for all different manners. Lawyers, in our profession, we're doing a lot by Zoom now. There's Zoom court conferences. There's Zoom. I just did a Zoom mediation on Friday. There are Zoom depositions. So, I think Zoom and other video conferencing platforms are going to be used widely to keep people separated.
Right. So for Zoom, this has been a good thing.
Well, certainly amazing for Zoom. Yes, I think Google has hopped on board and they have a platform, and we use a Google platform for our email, and they now have a video conferencing. So we use that in the office, and Facebook, I think, might have something. There's a few different ones coming out, but yeah, Zoom is obviously the leader.
And some firms, law firms, even retail employees are going to have a reduced need for the same number of employees. What is the best way to go about that if an employer has to downsize, and what rights might an employee have if that happens?
Yeah, so that is a huge issue, and I'm glad we got to that point. That certainly layoffs are widespread. We're already seeing them. There are going to be a number of layoffs which are certainly legitimate. One thing we have our eye open to is using the whole COVID issue as an excuse to reduce workforces and to try to paint it as legitimate, where it's really just either being used illegitimately, outright, or illegally to eliminate certain portions of a workforce. So, for instance, if a workforce wanted to, or an employer wanted to eliminate women, they might use COVID as an excuse to perform layoffs, and they could target, again, certain segments of the workforce. So we're open and looking at those, but there are going to be very legitimate ones as well, and things that employers can do to ease the pain, to the extent pain can be eased from losing a job, are severance packages. Larger firms will have, usually in a handbook or in a policy, X amount of weeks of severance for X amount of years worked. Others will just kind of, who hadn't anticipated doing layoffs, just off the cuff, might offer a standard 2 weeks, or might be more generous and offer, months or something.
And this also may be a temporary situation while firms work toward regaining their clientele and just see how things will be in the next few weeks and months.
Yeah, so there's the concept of furlough, which isn't necessarily a distinction between a layoff under the law, but I think the kind of commonplace idea of a furlough is that there's an expectation that she'll be brought back at some point. So certainly some firms are doing furloughs where they're just laying people off for a certain period of time or an expected period of time, just to reevaluate how things look when we really get back up and running fully.
And how can the employee try to preserve the furlough idea as opposed to a firing or quitting? Yeah,
again, I mean, these are all kind of layperson terms under the law. They all kind of look the same, whether you call it a furlough, whether you call it a layoff, whether you call it a firing. But generally speaking, the term firing has the connotation of being for cause, and that you're completely being eliminated.
Maybe laid off was a better word.
That's why I just want to make the distinction. So, and layoff generally means that there's some kind of a reduction in force or a reorganization. And again, a furlough generally has the idea that it's temporary for just a period of time.
How can the employee try? Is this something the employee can talk to the employer about? Are there unemployment, pandemic unemployment? What sources or resources are available to the employee?
So lawyers are always available. Obviously, there's firms like my firm. The Nassau, I'll give a pitch to the Nassau County Bar Association, has a volunteer program right now. I'm a member of that program as well for employment questions. So you can reach out to your local bar association. There's a lot of information on the internet, and the New York Department of Labor has a ton of information about unemployment benefits. There is traditional unemployment. So that's the program everybody's familiar with. Before COVID, if you got let go or you lost your job at through no fault of your own, you could apply to the New York State Department of Labor for unemployment insurance. There is expanded benefits now under the Pandemic Unemployment Assistance Program, and that expands the monetary benefit, and that expands the people that are entitled to it. So if you can't work, usually if you can't work for some reason personal to you, you're usually not eligible for unemployment. Under the Pandemic Unemployment Assistance Program, if you can't work for, say, you can't get to your work because maybe the trains are shut down and you need a train to get to work and it's shut down because of COVID, you might be eligible for unemployment assistance. If you
even if the work is no longer there.
Even if the work, certainly if the work is no longer there and you couldn't work because there's no job for you, you have to be ready and able to work and willing to work for unemployment. But if your job isn't there anymore, that's certainly a traditional reason why you would apply for unemployment.
Okay, and we're going to talk about some issues a little bit later in the program, but I want to remind our listeners that you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College. Today we're talking with attorney Matthew Weinick, and as you've heard, he acts usually on behalf of employees and works to preserve their rights in employment situations, and especially there's so many new concerns of employees because of the pandemic. What are suggestions do you have for employees in meeting the challenges of the pandemic and working out a safe way for them to return to work or keep them compensated while their employers are in a state of uncertainty?
That's a tough question. But what I always start with is that you have to do what's right for you. So you have to make an assessment of what you're comfortable with. If your workplace is not taking measures which you feel comfortable with and you think you're going to be at risk or bring something home to your family and you can't bear that risk, you have to make the decision. And if you can't go back to work, you don't go back to that workplace. And I know that's not always the easiest decision to make or the advice people want to hear, but that might not be the right place for you. If your employer isn't taking care of you, I think you have to question whether that's the place you want to be. Again, under the Pandemic Unemployment Assistance Program, there are increased benefits. So whereas you make the decision to not go back to work for whatever reason under traditional unemployment, you're probably not qualified. Under the Pandemic Unemployment Assistance Program, you might be qualified. So you can have that little bit of a safety net, as long as it's there for you. Some benefits expire on July 31st, 2020, so that won't be here forever. But that's one piece of advice. Certainly conferring with a lawyer and talking about what your options are. Everything in employment law, as in many other areas of the law, is so fact-specific. So I really do recommend just giving a lawyer a call. As I said, my firm, we're very happy to pick up the phone and just talk to workers for a little bit without a charge. But even if you're calling lawyers who are charging, there's the Nassau County Bar Association, and you can get help from a volunteer attorney through that program. But speak to a lawyer about what's happening in your workplace. What are your rights? It's important to speak specifically about your situation.
What if the world of work has changed, whether you're a professional, your support staff, you're some type of lower level in the organization, but you don't have the background to use technology, the computer skills that you may have been a clerk before, or you may have been a paper pusher before, and there's no more paper, there's no more procedures, there's no more file clerks.
So if the situation is that your job doesn't exist anymore because of what's happened, again,
at least in the same way you did it.
Yeah, I mean, there's certainly a lot of training programs in the Department of Labor on the website. As far as retraining, they can help you with some retraining. And so that's an excellent resource. The entire website, the Department of Labor, it's really an excellent website for both the unemployment issues and kind of some retraining issues. There's material out there. But, again, that's not so much a legal question, but I think, that is a question maybe about a society that we have to face is, how are we going to pivot into kind of a new post-COVID era where some of these hands-on positions may not be available anymore. We might have to start thinking about how we are going to retrain people and what programs we're going to put out there.
But in the interim, those people who've been let go because of technology, because of less need or reduced need, can benefit from some of those programs you mentioned.
Absolutely. And again, just to kind of help keep yourself afloat if you have been let go, unemployment is definitely a key element there.
And do you have any suggestions on trying to reach unemployment to find out what your rights and benefits should be? Sometimes it's a challenge for high-tech people or low-tech or no-tech people.
So on the volunteer side of what I do with the Bar Association, that's probably the number one question is, help. I'm trying to apply. I don't know what my status is, or I can't even apply. I can't get onto the website. That's the number one issue. And it's one of those things where I don't have a good answer is I don't have any better access to the system than anybody else. As lawyers, we don't have the super secret access to the Department of Labor website. I don't
hotline to the governor.
I don't have the hotline to the commissioner. I don't have a backdoor. I don't have the contacts. It's unfortunately they're facing some of the issues that everybody's facing. Their people are working remotely. Their people are overwhelmed. The volume is just, even if they were in their offices doing their jobs normally, the volume is something that, hasn't been seen in quite some time. So it's tough. Stick with it. The website has been overhauled. It is, as I understand it, I haven't gotten access to it because I haven't filed, and we generally don't help people file. But from what I understand, it is pretty intuitive to use, and it will give you updates. If you log in with the ID that you get from New York State government, you should be able to track the progress of your claim.
Okay, and you should document when you called in, when you tried to log on, and keep records of your employment efforts. And let's just go back to Matthew. You mentioned with some of the areas you can help people and employers coping with all this. Do you have information available on your website? And give us your contact information. Oh,
yes, absolutely. We do. We have a lot. We've been blogging continuously throughout the whole pandemic. We did we got a little bit busy and stopped doing it after a time, but we put out a series called the Lockdown Video Series. So we just we did some, video logs about some COVID information. And that's all up on our website. It's LINYC employmentlaw.com. And
just go ahead one more time. Just give it one more time.
Sure. It's LI as in Long Island, NYC as in New York City, employmentlaw.com. And if you still didn't get it and you want to give me a call, my phone number is 631-352-0050. Our phones are routed to our home, so even throughout the pandemic, we've been answering them, and they are manned.
And just give us your number one more time.
631-352-0050.
And again, you'll offer like a limited consultation to see if you can maybe help someone or steer them in the right direction, which is a good thing for all lawyers to do. I would like to thank our guest, Matthew Weinick, who's been talking to us about some of the rights of employees as they go back to work, or they've been let go, or may try to receive unemployment. And please visit the website or contact him in person if you have other questions. And the Bar Association may have other free resources and seminars and programs.
Thanks, Ken.
You've been listening to Law You Should Know on 90.3 WHPC. You and others can listen to this program again at nccradio.org. Please join us next week at the same time for another program on Law You Should Know.